Well, it's great to be here. Again, my name is Jeff Robbins. I'm the director of the Oil and Gas Commission. Wanted to start. I know many of you in the room. I don't know many of you in the room, and I wanted to provide you some perspective of who I am. I'm the third character over there. Next to me is Mike Wozniak, and this is an oil and gas operator. And this photo is from 2001. I was the attorney for La Plata County, so I was a West Slope attorney for local governments for a number of years. And I moved to Durango in 1996 and practiced there for the last 23 years as a private attorney. One of my first clients was La Plata County, and we were dealing with the oil and gas boom that was happening down there then. We had regulations. We were sued by the Colorado Oil and Gas Commission, which is what I'm running now. We lost one of those lawsuits. We won one of those lawsuits. We tinkered with our regulations. We created the concept of a memorandum of understanding, I think for the first time in the state of Colorado, and we did that with BP. La Plata County now has 18 MOUs in place with its operators, and it's in a good place in terms of what its regulatory framework looks like, and I'm pretty proud of where La Plata County got to be. I also practiced before the Colorado Oil and Gas Commission. I met Mike Wozniak about 2 weeks ago, and he had this framed in his office, which I thought was kind of funny. But this is I think my initial hearings before the COGCC, and they were doubling the density in the field, and we were raising health, safety, welfare, and environmental issues back 18 years ago. More recently, for the last 10 years or so, I've taken the experience of working with oil and gas and local governments, and I've been working with front range local governments and addressing the issues of oil and gas development near homes and people. I've represented a number of those front range communities. In 2014, the Governor Hickenlooper appointed me to his 2014 Oil and Gas Task Force, and I spent a year working on that. Which from that, some new regulations arose at the Colorado Oil and Gas Commission. And now here I find myself as the director of the Oil and Gas Commission, and I'm excited about that. I'm excited about the opportunities we all have with the new legislation that was enacted. And I'm here to sort of talk a little bit about what that is, what that means, what that doesn't mean to you today. So, to start, what does Senate Bill 181 do? Well, it reprioritizes the Commission's mission and approach to regulating oil and gas. It changes the mandate of the Commission from fostering oil and gas development in a manner that's protective of health, safety, welfare to regulating oil and gas in a manner that protects health, safety, and welfare. The second big fundamental point of 181 is it allows discretionary authority, express authority to local governments, that local governments can regulate oil and gas. Prior to 181, local governments had authority to regulate oil and gas, but it was implied. There wasn't an express recognition of that authority in state statute. And this state statute specifically says local governments can regulate oil and gas in all areas related to the surface, which is what local governments are good at and know what they, and know how to do surface regulation. It maintains that the Oil and Gas Commission will continue to regulate the sort of the downhole and the technical aspects of oil and gas development. And I think that makes sense. That's what this commission has a good ability to do. With both the delegation of authority to the Commission and the delegation of authority to local governments, the amendments in the process of 181 as it went through the 5 weeks or so in the legislation, amendments were brought in that put some parameters for both the state and the locals in terms of how they use that authority. And that authority has to be reasonable, and it has to be necessary. It needs to be done so in a manner that's minimizing and mitigating impacts. And as the director of the Oil and Gas Commission, I'm comfortable with where this bill lands in terms of what it's directing the commission to do, because I think it makes sense for the commission's exercise of that authority in a reasonable and necessary manner. That makes sense to me. When a local government uses its authority, it too needs to base that regulatory approach on reasonable and necessary measures. And I think that makes sense too at the local level. So those are the two main components of the bill. There are a number of other side components, such as it changes the commission twice, and I'll get into that in just a bit. One thing that I wanted to emphasize, in my opinion, what the bill doesn't do is mandate any form of statewide moratorium on oil and gas development. At the commission, we're moving forward on a day-to-day basis, and we're going to continue to process and approve permits. I think for local governments that decide to use this authority, I don't think that this gives them authority to sort of say, we're going to draw a big window around this area within our community and we're not going to let oil and gas get developed there. I think that's beyond what is reasonable and necessary. I think it can allow a local government to look at this, a area on a site-specific basis and say, as we're looking at this siting, maybe it makes sense to move it over here from here, things of that sort, but again, not sort of a global mandate of not allowing oil and gas development to occur. Where will it take us? I think that it does establish greater collaboration for regulators, for the Oil and Gas Commission, for local governments. There's a mandate to the Air Quality Control Commission to implement regulations around minimizing emissions. I think all of this is telling us that we're going to increase certainty for permitting processes within the state. I think that it provides to the state, we're supposed to take a look at regulations on cumulative impacts and alternative site. And I also think this is a directive from the legislature that now that there is an express delegation of authority to local governments to regulate, as well as the state, that both the state and local governments need to work together to implement how we're going to do that. And one point I want to make too is the delegation of authority to local governments is discretionary. It's not a mandate. It doesn't say every local government in the state of Colorado now has to go regulate oil and gas. It's kind of the opposite. If a local government wants to regulate oil and gas, they now have express authority to do so, but there's not a mandate to do that. And for many local governments, I think the majority of local governments who have not regulated oil and gas in the past, I don't think they're going to hop into the oil and gas regulation game. I think there will be a handful of communities on the Front Range that have historically regulated oil and gas, and I think they will use this authority to continue that regulation. But for the vast majority of the state of Colorado where oil and gas is happening, the regulatory approach between the local government and the operator and the state is probably going to remain somewhat business as usual, because I don't think there's going to be a lot of change in the majority of the areas where we see a lot of oil and gas development happening. How will we get there? There are a number of things that my staff and I are working on at this very moment. We have a number of things that we need to do to implement 181. We're in the process of creating what's called objective criteria. What that means is the bill says to my commission that you need to create rules in 4 different areas over the course of the next year. And those areas are a rule around what it means to move from fostering oil and gas development to regulating oil and gas development. So that's a rule. Rules around alternative siting of oil and gas facilities, which gets at sort of the nub of large-scale operations in and near urban communities. Not so much so here on the West Slope. Your siting issues are not necessarily the same as you see on the Front Range. And as we work through those rulemakings, we want to make sure that we take input from the various localities so that we're developing a set of rules that works on the Front Range as well as works on the West Slope. So that's the second set of rules. Third set of rules is we're directed to evaluate and address, if necessary, what are cumulative impacts from oil and gas development. And then fourth, we're to address rules, relook at the flow line rules and look at the information associated with flow lines. I think there's another half of a rule, which I've been calling it, but the rule around this interrelationship between local governments and the state regulatory agency. Obviously, we need to look at that, and we need to develop protocols around that so that we can create some certainty for operators and all stakeholders about what that's going to look like. So we've got to finalize this, the objective criteria. And what that is that's the criteria that the commission will use to look at pending applications before those rules get in place to ensure that if they get approved, they're going to meet the prism of 181. They're going to be protective of health, safety, welfare, and the environment. My staff and I have been working tirelessly for the last couple of weeks once we knew what 181 was going to look like to try to get this up and rolling. We have 30 days from Tuesday to get the criteria published. We're going to try to publish it tomorrow. And then we're going to have a window for public comment, and then we're going to finalize those objective criteria soon so that we can continue to let the day-to-day operations of oil and gas move forward. Other things that we're doing at the State Commission, once the bill was effective, which was at 4:08 on Tuesday, pending applications before my commission have to have new or are judged by new criteria from the bill. As an example, pooling applications that are pending at the Oil and Gas Commission now have to satisfy the 45% mineral estate ownership requirement. And they also have to show that there is a good faith offer to the mineral estate. So those applications are going to require some additional information so that we can make sure that they're ready to roll when we have our May hearing. Similarly, drilling and spacing unit applications, sort of the downhole underground zoning of oil and gas, there's now a requirement that those take into consideration protection of public health, safety, welfare, and the environment. So we're working at the State Commission on what does that mean? What sort of new information do we need to apply to pending permits? Form 2 and 2A have to have, and that's the oil and gas location and the well permits, they have to have a provision to determine whether the local government in that jurisdiction is involved in siting. And if so, did we get that taken care of? So we're quickly putting together guidance documents for industry, for the stakeholders about how we're going to try to implement those sorts of things. I had a meeting on Tuesday with the operators in the state of Colorado. There were about 160 that showed up, either telephonically or in the COGCC room. And we had a two and a half hour discussion, tried to answer questions, tried to be open, honest, transparent about what we're doing at the commission to implement 181 in a manner that is understands what the direction that we were given from that, but in a manner that continues to allow the day-to-day business of oil and gas to happen. So we're going to try to post not only the objective criteria tomorrow, but we're going to try to hopefully post the guidance documents so that folks in industry understand what are the things you need to do now so that you're satisfying 181. So we're trying to be proactive. We're rolling up our sleeves. I'm working with my staff in 2 to 4 hour blocks with my senior staff to try to develop this information so that we can keep this, keep all of this moving forward. We rescheduled the April hearing to probably May 2021. That was not just to delay for delay's sake. The fact of the matter is that as of Tuesday, the current commission no longer exists. And as I mentioned earlier, Senate Bill 181 creates the Oil and Gas Commission, recreates the Oil and Gas Commission twice. Effective immediately, the current 9-member volunteer board changes to a different construct of a 9-member volunteer board. There's a new seat for public health. The environment and wildlife seat, which used to be 1 seat, is now 2. It reduces the industry seats from 3 to 1, but it does provide that we could have a technical person that's smart as a commissioner. So there's some opportunities there. So we are, we've sent emails out to all of our current commissioners, and we said, please reapply. And we've also opened up, or not we, it's really not me, it's the administration. The administration has opened up on its website for other interested members of Colorado. If you fit one of the categories, we'd love to have you apply for the volunteer commission. So this volunteer commission is going to be the commission responsible for implementing the rules that I just talked about. We're excited about some other opportunities that 181 provides us. We're going to create administrative law judges, which is going to take some of the burden off the Oil and Gas Commission and what they do on a daily basis and allow them to be more technical, more regulatory, and working toward implementing the rules. So that's 181. I'm also here on behalf of Department of Natural Resources. I wanted to introduce everyone to our new DNR Director, Dan Gibbs, and Deputy Director, Tim Mock. Here are some other folks that we have on board. I'm really excited that Julie Murphy, who is the former Director of the Oil and Gas Commission, is now an Assistant Director for Energy and Minerals, and she's going to help us with the rulemaking. Just shortly to introduce Dan, he was a Summit County Commissioner from 2010 to 2018, so he's a West Slope guy. He also was a representative in the House of Representatives as well as the Colorado State Senate. He's worked on issues concerning wildlife throughout his record, and we're really excited to have Dan. He's been instrumental in providing the assistance that we need at the Commission. Tim Mock is also with us. He is a former county commissioner as well, and we're pretty excited to have him on board as well. Here are the 4 priorities from DNR to secure sustainable funding for Colorado parks and wildlife. They want to increase access to and availability of public lands. With regard to parks and wildlife, Dan told me he wanted you guys all to know that he's seating or trying to determine who the new director of the Colorado Parks and Wildlife is, and we've got some West Slope representatives on that board to try to figure out who that person should be, and he's working hard on that. We have the new Colorado Water Plan, and they want to make sure that we implement that successfully. And we also want to ensure, obviously, the smooth and effective implementation of 181, which is the Oil and Gas Act that I was speaking to. So with that, I think I'm 2 minutes ahead of time, which gives us hopefully some opportunity for questions, because I would really like to try to answer questions from members of this group.
So I'm Tom Jankowski, Garfield County Commissioner, and what I want to go back to is there's not going to be a moratorium on permits, and I just want to, is there going to be a moratorium on new permits during the rulemaking?
No, there's not going to be a moratorium on new permits.
If there are new permits that come through Garfield County, there's not going to be a moratorium.
Right. So what the Colorado legislature provided direction to all of us is they felt that there's 6,500 permits that are backlogged in the hopper for the Colorado Oil and Gas Commission, and we're going to get new permits, and we also have to do a rulemaking over the course of the next year. And what the legislature said was, we don't think it's right and accurate that all those permits get a free pass, because if that's the case, then this bill is fairly ineffective for the next 5 to 10 years. But the legislature also said, we don't want all of those bills to be held up during the pendency of this rulemaking. And so that's where this objective criteria come in, where the director and the commission will take a closer look at permits that require a closer look under 181 to ensure that they're meeting the environment protection, health, safety, welfare. But for, I would assume, a majority of the permits that are smartly done and ready to go, they just continue through the process. And even for those permits that may be delayed a bit, it's not this permit gets stuck over here until July of 2020. Instead, it's, let's look at this, let's look at the operator, let's look at the local government, and let's make sure that this meets the mandate of 181, and then let's make it good to go.
Okay, then on cumulative impacts, is climate change going to be, and maybe that's a better question for Jill Ryan, but is climate change going to be tied into that?
So the bill provided direction to the Oil and Gas Commission that it needs to address and evaluate potential cumulative impacts from oil and gas operations, and that's really a quote from the bill. The determination of what that means is going to be developed and interpreted and done via rulemaking by the new volunteer 9-member commission. And that's going to be through a robust, transparent stakeholder process. I invite all of you in this room who are involved in this to be a part of that process, to bring your perspective to the table, to provide what you think that means or what that doesn't mean. Obviously, we'll have industry at the table, and we'll have local governments, and we'll have environmental groups, but to have everyone at the table so that we can bring all those prisms in and make a determination and allow the commission to make the right determination of what that means and what that rulemaking ought to look like.
Okay, and final question is, will the governor still be the one to appoint the commission?
Yes, the governor is the appointer of the volunteer commissioners, and they have to be confirmed through the Senate. And then once the commission turns into a professional commission in July of 2020, that's 5-member paid full-time commission, something industry was very interested in seeing happen, and it is in the bill, then the governor would appoint those commissioners, again, subject to confirmation by the Senate.
John Justman, Mesa County Commissioner, and I guess one of the things that I question is, how do you really define reasonable and whatever else the word is? I mean, that's a pretty subjective rule to anybody and everybody, and while I may think I'm reasonable and the commission may say that's very unreasonable, then I don't know how we're ever going to resolve that.
Well, again, I agree that that those are the terms that the legislature have delivered to us, and just as with regard to the cumulative impacts, how that gets defined through the rulemaking. And so I encourage, again, come to the rulemaking, be a part of the stakeholder process, bring your ideas of how that should be defined so that the Oil and Gas Commission, the volunteer commission, gets it right in terms of what that rulemaking looks like.
But based on what I saw on the 181 testimony, what commissioners really found, I mean, I don't know what, irritating. Many of us are in D.C. at the legislative conference at NACO when they hold the hearing for it. I know Commissioner Kirkmeyer left early so she could testify, but based on a lot of things that were, the comments that were made, I don't know that a lot of our concerns were really addressed, and it doesn't make me feel better as a commissioner. We've been through this downturn before in Mesa County. We're doing better today than we had been doing for several years. And it's a completely different world on the Front Range. On the Western Slope, our economies, almost all the counties, we struggle most of the time. And we're doing better, but this looks to me like it's going to put us back into the thing when we're, in a year or two, we'll be meeting with department heads telling them how they're going to take a 5 or a 10% cut in their budget. And hopefully that won't happen, but that's our concerns.
I agree. I hope, and that's not, my intent as director of this Oil and Gas Commission is not to approach it from the perspective that you just outlined. I spoke to Club 20 last week, and I answered similar questions, and I tried to provide perspective that we want to hold open and robust and transparent processes. To the extent that folks felt like they weren't heard by the politicians, I'm not a politician. I'm a director of the Oil and Gas Commission, and I want to hold a process that allows all interested parties to come and be a part of the process. I mentioned earlier that I firmly recognize that oil and gas development on the West Slope is a different concept than oil and gas development on the Front Range, and I think as the Oil and Gas Commission takes into account the rulemaking that it's supposed to do under 181, it needs to take into account the fact that there are differences. And I think that the Oil and Gas Commission can be successful in that.
Yeah, I remember taking then Mayor Hickenlooper, before he ran for governor, out here on tours. And I remember him expressing the concern at that time of keeping a technical commission intact, because he was a professional petroleum geologist for a while. And I've seen the commission makeup change over the years from the 5-member technical commission to now the 3-member technical commission to now 1. Doesn't it make sense to have a professional petroleum engineer, professional geologist, geophysicist, a certified professional landman on that commission? We used to use the argument, if you have a medical commission, you have doctors on it. So if you have an oil and gas commission, wouldn't you have technical experts? Since you're regulating the downhole, you have to have a knowledge of reservoir engineering, you have to have a knowledge of geology or geophysics. Why only go down to 1 technical member?
Yeah, I tend to agree with you. I don't know what the Colorado legislature's thoughts were about how it's reduced. as director of the commission, would like to use, do the best I can with the legislation that's been handed to me. And part of that is that we do have that one wild card slot of the technical person that has expertise in this area, and that may be an opportunity there to do that. I think that if we are handed this and this is what our commission is going to look like, we're going to have to rely on a lot of the science and the technical experience that my state agency has. So I've got a bunch of really smart technical engineers, and maybe we're going to have to rely on them to inform the commission on the technical components of this. We're pivoting as best we can with the legislation that we've been provided, and we're going to do the best we can in terms of making sure that the volunteer commission has an understanding of the technical components, because that's part and parcel of what they do.
Hi, Jeff, thanks for being here, and good luck with your efforts in the next couple of months. I'm Brad Mueller. I'm the local government designee for Greeley. And I've got a fairly simple question, and I'd ask you to not read too much into it. Through your presentation, you've made reference to the Oil and Gas Commission instead of the Oil and Gas Conservation Commission, and I wondered if that was deliberate, or are we anticipating a change, or whether that's just easy shorthand for you? And
it's just easy shorthand for me.
Okay.
The Oil and Gas Conservation Commission is still the technical term for it. I'm just trying to get through a lot of information and didn't use that word, but that was not deliberate.
Yes. Mr. Robbins.
Yes.
In anticipation of, right here,
Oh.
to your left.
Oh, sorry. I was like, where is this guy?
I've never been able to hide from anybody. In anticipation of disputes arising between industry and local municipalities, how would the COGCC intervene at all? And if so, how do you see that playing out?
I guess I'm hopeful that we don't have disputes between local governments and the COGCC. I'd like to I'd like to take this opportunity where the Oil and Gas Commission and local governments develop protocols for working together. Obviously, we have new authority for a handful of local governments that are going to use it. The new authority also says local governments can be more protective in their regulatory approach than the state commission. So we're going to need to determine, what does that mean? How does that look? And make sure that we work through that. But my goal is not to create a regime where we're creating more disputes, but to lessen disputes and to establish reasonableness and certainty in terms of how the locals in the state are doing this so that we can move forward.
One other question. One of the sponsors of 181 talked about on the House floor the intent to professionalize the COGCC. One of your slides mentioned that. What does that mean?
Well, the Act says that starting after we implement these rules, or by at least July 1 of 2020, there'll be a 5-member professional commission. And they'll be full-time paid commissioners. This will be their full-time job. The Act does not say what that means other than sort of what I just mentioned. It talks about how they get appointed, et cetera. And so that's one of the tasks that we're going to have over the next year, is looking to other jurisdictions in terms of how they do professional commissions. We'll probably hold a stakeholder approach to that too, to get ideas from the regulated community and others about what does a professional commission look like? What do these people do on a day-to-day basis? Right now they meet every 6 weeks and they're volunteers. There's a lot of business before the commission. I think having a professional commission allows for some tremendous opportunities to have them act often and more frequently, and that's probably going to be a positive thing, but we haven't really rolled up our sleeves in terms of looking at what that actually looks like just yet.
Hi, Commissioner Robbins. This is Kent Jolly. I guess I'm an ex-commissioner at this point. I know that other commissioners are also wondering or haven't got the email, but you mentioned that there's going to be a meeting on May 20th. That will be with the new commission, volunteer commission, I assume.
Yes, that would be with the new commission.
you suggested that we're all able to reapply, but I guess your intent is to have a commission empowered or impaneled by May 20th?
Well,
For that meeting?
It's not my intent, it's the administration's intent to empower the new commission that 181 calls for just as soon as it can so that we can have the May hearing and move forward. And all current commissioners should have gotten an email 2 days or yesterday morning from the Director of Boards and Commissions, I believe it is, inviting them to reapply to the new commission. And if you didn't get that email, after I'm done here, I'll go make sure that I forward the copy I got to you.
Okay, I'm not the only one. But is there a time to get confirm this commission with the Senate? And if not, I mean, are they going to?
One of two things
go
happens,
forward?
and I'm new to this, but if they're seated before the adjournment of this session, then they would need to be confirmed or they would need to be reseated. And there's also the opportunity to get them seated right after this session is over, and then they would be confirmed next January. But either way, we have abilities to get the new commission up, running, and ready for the May hearing.
Because we had commissioners that weren't ever approved by the Senate last year or confirmed. So this new commission will be responsible for imposing the rules or writing the rules that the pending permits will be approved or disapproved on it, it sounds like. So it seems like there's a logjam right from the gate if we don't have
No, that's
rulemaking.
actually, let me clarify something. So the new commission is charged with adopting those 4 sets of rules that I talked about. And they've got to get that done within, we're hoping, the next year. During the pendency of that, the current pending applications can still move forward based upon appliance of the criteria that we're developing with industry stakeholder input, and those would allow pending permits to continue to move forward. So we're trying to do 2 things at once. Move forward with the rulemaking, but establish a predictable, certain sort of approach for current permits so that current permits can continue to be approved.
I'm just skeptical that we can move ahead without the rulemaking happening. If as climate change, as an example, has to be considered in approving new permits.
Well, we are at the commission.
I don't know if I'm making that plain, but I'm.
No, I understand the
Okay.
perspective, but we're trying to walk and chew gum at the same time. We're trying to establish a situation where we're going to get the rulemaking moving forward, and we're establishing a situation where the operators have some sense of how that we can move forward with permits pending that rulemaking. We're trying to do both.
Okay.
Director Robbins, thanks for coming out and entertaining our questions. Could you also clarify the difference between the commission and the technical review board that's allowed in the bill?
Sure. So the statute, Senate Bill 181 suggests that if a local government wants to be the siting regulator, that they can go first and site an oil and gas facility or have a regulatory approach for that. The legislature also recognized that local governments don't necessarily have technical experience with regard to what does a proposed location, what are the implications of that to downhole effective recovery of the mineral resource. And so the legislation establishes that either the local government or the operator can ask my commission for a review, a technical review of the implications of various sites to recovery of the mineral resource. And so we're going to develop how that's going to look, but I think that's going to be helpful. I've represented a lot of local governments in the past, and I know that they don't necessarily have that scientific experience or expertise as to what's happening downhole. And I think that's a positive development to make sure that when a local government is siting surface locations, that they're doing so in a manner without negative implications for mineral resource recovery.
Good morning. This is Kathleen Conti, Arapahoe County. My question is, because we're dealing with a system where it's going to be the most astringent of the rules that is what's followed, what if we see a intermixing and the state is more stringent on one rule, the county is more stringent on the other, and we see a intermixing? Who is going to be the determining agency to put together, this is going to be the list that has to be followed in this county or this city? Is it going to fall to the COGCC, or is it going to fall to that particular county or city to put together that list for their conglomeration?
Let me clarify one point before I answer that question. The legislation that was introduced in the Senate did have that component. It said where there are competing regulations in a section or in an area, like just a subject area, then the more protective regulation would be the applicable regulation. That was changed. And so that was removed from the legislation. And what the legislation now doesn't speak to that. All it speaks to is the fact that a local government can be more stringent than the state in a regulatory arena, which sort of gets at that preemption standard that used to say local governments couldn't do that. So that sort of competing who's more protective was removed from the legislation. So I think that's probably positive because we don't have to have that understanding. I still think there's going to need to be a positive working relationship between local governments and the state agency for those handful of local governments that are going to, roll up their sleeves and get really involved in this. I'm going to want to try to establish an interrelationship so that we all understand how the two work. For those local governments, I think mostly they're, the handful or so that are going to do this, I think they're going to want to go first in citing, et cetera. And so we'll just let that play out. That's what my mandate is to my commission. And then once they're done, then we would come in and provide the downhole technical permits, et cetera, associated with mineral resource development.
Hey, Aaron Kirshner with the City of Westminster. I'm over here.
Oh, here.
Yeah. And correct me if I'm wrong, I believe the new bill proposed language that said there's no indefinite moratoriums allowed. Has there been any conversation, and maybe it's going to happen at these rulemakings, that will define what term of length is allowed if cities try and do moratoriums? And if they do, is it going to fall back to the commission to determine what's allowed and what's not allowed? Or
Okay, again, to clarify, and these are great questions, and it's good that we can clarify some of this stuff. The bill does not speak to moratoriums at all. The language is not in the bill. And so local governments will need to fall back upon Colorado case law with regard to whether they decide they want to do a moratorium or not. And I think the case law allows for short, reasonable moratoriums that are associated with the need to do regulations. Long moratoriums that aren't associated with the need for regulations I don't think they're allowed. And the commission will really not have any say one way or another with regard to what local governments do on that front. So glad we could clarify that.
Cy Woodruff, Rio Blanco County. Just a question, how I understand this. We deny someone the right to drill, whether it's done locally or the state level. How do we compensate that mineral rights owner? A lot of the money in this area, is derived to those owners historically or otherwise. But the way I'm interpreting this, we or the state now have the authority to say no. How will we compensate these people?
Well, let's focus on local governments to start. Local governments have land use authority. They've used land use authority for decades, and they're, I think, fairly good at land use authority. Now they have authority over the mineral estate and development of the mineral estate. When I represented local governments, I always tried to provide reasonable, pragmatic advice that if you take an action using your authority that denies all reasonable uses, you're subject to a takings case, whether that's a surface use or whether that's a mineral estate use. And so I think that is still sort of the final arbiter in terms of if denial of mineral resource development happens, then that is still sort of the pivot for that operator. Back in the back.
The Front Range keeps getting lumped together, and the Front Range is a very diverse and very unique thing. And so I would just say that when you look out to the smaller communities, we don't have the resources or the staff to help participate in a rulemaking process to make sure that small communities are kind of covered in the process. So I would encourage everybody to keep that hat on, because little towns just don't have enough people to come to all those meetings all the time. So look at us as a whole flat, as opposed to what the few communities that are lumped up against the mountains that have indefinite and deep resources.
And I appreciated meeting you earlier today, and I think that's an excellent comment, and I understand that. And I'll have a little town day where I come out to meet with the little towns so that we can get their perspective on the rulemaking, because you ought to be heard on that front too. Again, as we do this rulemaking, we want to get perspectives from everyone, and I understand that you don't have the time or the people to drive down to Denver, find a parking spot, and come to the commission. So we'll do that. Over here.
Is there a contingency plan in place for, I'll say, when severance tax revenue declines to fund the Colorado Water Plan?
Well, I think that's taking an assumption that severance tax will decline, assumption I probably don't agree with, and I'm not a severance tax expert, so I really am probably not the right person to try to answer that, but I'll go back to state government and see if I can find someone that could answer that question. Going once, going twice. Kirby, I've exhausted them.
I want to be able to do this again next year, so I thought I shouldn't cut off your Q&A. Because, I don't know, people are interested in what you're up to.
Okay.
How about a round of applause for our director?
Thanks.